Hello, we just finished a very interesting OECD roundtable on the subject of the non-price effects of mergers, and I'm very lucky to be joined by one of the experts for that roundtable, Orla Lynskey, who's an assistant professor at the London School of Economics. Orla, thanks very much for joining us.
Pleasure to be here.
So one of the things that we talked about, the traditional non-price effects are often quality or variety, sometimes even innovation, but it was really interesting that you kind of introduced a new element, so talking about privacy and merger control. So can you talk to us a little bit about why you think competition authorities should consider privacy?
Absolutely. So today, from what I presented, I suggested that there were two potential ways in which data protection or data privacy can be relevant to the assessments of competition authorities. And one of them is if you look at data protection as something, a policy on which different firms compete. And so, as such, you could have firms that are offering a better or a lower standard of data protection, and data protection would then be an element of quality overall.
Right.
And that view has been accepted in principle, at least, for instance, by the European Commission in the Microsoft LinkedIn decision. Okay. But we haven't yet seen the blocking of a transaction or the imposition of remedies in order to deal with that dimension of competition between firms. The other way in which I think data protection is relevant is that it forms part of the overall background competitive landscape that competition authorities need to take into consideration when undertaking their competitive assessments. And so there, the assumption is often that because this dimension of competition is regulated, so we've got data protection legislation, for instance, that the market, from a consumer perspective, functions perfectly, let's say. Whereas in fact, I think if you look underneath the hood of the regulation and look at how these markets are functioning in practice, you'll see that the situation is a little bit more complicated. And here I was referring to the work of Farrell, a 2012 paper on the dysfunctional equilibrium in these data-driven markets, with the idea being here that we have a bit of what you might call a vicious circle, which is that even in individuals who are really interested in privacy or data protection might assume, based on various market circumstances, for instance, the excess of information that they need to digest in order to make informed decisions and various other factors, that they might find that ultimately the rational thing to do is to not care about privacy or data protection. Exactly, right. Do nothing. And so that then means that those firms that might be inclined to compete on data protection will lose the incentive to do so. And then we feed back into that loop by saying there's less incentive for firms to compete on data protection and privacy. And interestingly, yesterday in the UK, which a consumer protection organisation released a report where they also noted this dynamic in the market, and they're calling it one of rational disempowerment. And so one query I had was whether or not competition agencies should be taking into consideration that level of detail of how the market is in fact functioning when as a backdrop to their competitive assessments. So that might be relevant to a question, for instance, of is data protection a parameter on which firms compete because it's valued by consumers? Right. And so it can be relevant in that way.
So just because I guess we have these behavioral biases doesn't mean it's automatically just a consumer protection issue and competition authorities should leave it by the wayside.
Yeah, absolutely. Because if you see data protection as an element of quality, then you're internalizing it into the consumer welfare standard. Right. So this doesn't mean that competition authorities should go out of their way to pursue data protection goals. Yep. What it does mean is if all of the constituent elements of of competition oversight are fulfilled, so let's say if it's a merger transaction where the competition authority needs to gauge what competition will look like post-merger, then data protection could be an element of that assessment. However, it doesn't mean that a competition authority will simply sanction a firm because it thinks that their data protection policy is substandard. So right. I think there is a distinction there.
Wow, that's really interesting, really enlightening. Thank you so much, Orla, and thank you very much for joining us.